Child custody will come up in your life in one of two circumstances. Either you're not staying married to the person that you had children with, so it would come up in your divorce, or the child was not a child of a marriage and instead some other relationship that likely has broken up, or some other situation where orders are needed from a court to explain how this time will be spent with the children, how different decisions on behalf of the children will be made. If you're in the middle of a Texas divorce case or considering how a custody modification or suit affecting the parent-child relationship might play out, I think it'd be helpful to understand the difference in what people sometimes refer to as legal custody and physical custody. So legal custody, let's start there. When you're talking about legal custody, I think what you're talking about is the ability for parents to make decisions about their children's lives, well-being, behavior. And in Texas, there's a presumption that parents will be joint managing conservators, or JMCs, as it concerns their children. And that as joint managing conservators, they will have equal right to make decisions about their children's heads, meds, eds. That would be psychological decisions, health decisions, and educational decisions. So you can have joint managing conservatorship with someone as far as it concerns legal decision making, yet have very different physical custody. And when we're talking about physical custody, probably what you're referring to is your right to possess the child and to have parenting time with them. And even if you're joint managing conservators legally, you may not have exactly equal or joint parenting time. And in fact, the default or the presumption is that you won't, that one parent will have more time than the other parent with these children. And so physical custody would be things like every other weekend, when you spend time together, and how all of that works out. So they're related, but definitely different. And don't beat yourself up if that feels confusing. It is a little bit confusing, but just keep in mind, even if you can make the same decisions, that doesn't necessarily mean you're going to spend the same amount of time with the children as your co-parent. Different courts in Texas will treat the best interest of the child standard differently because judges are people and they have their own ideas about what informs the best interest of the child. Now, there are different court cases and different provisions in the family code that help put some meat on the bones and give some guidance for Texas courts. But a lot of the authority and power to determine what that is rests in the individual judge. But if you think about it, there's a practical way to think this through. Like, what is best for the kid and how do you know? A court would consider things like, okay, we want to make sure that this child is safe and that they are thriving emotionally, psychologically, and physically. So they're looking for information that informs them about whether this child is safe and thriving. So they might look to the behaviors of the parents, like who makes sure that the child takes the medicine they need, who gets them to their well care visits, who's involved with the school, who answers when the daycare calls, who involves their children in a whole lot of conflict. So these are the sorts of facts in your particular case a court might consider when determining what's in the best interest of the children in your Texas divorce or custody modification case. When awarding custody in Texas, a court is going to consider what's in the best interest of the child. And what they're going to look to is the behavior of these parents to see which parent they can trust the most to make sure the child is safe and thriving emotionally, physically, and mentally, like psychologically. So think about this. They'll look at things like, okay, who's the parent that does pick up and drop off of the kids? Who makes sure that the kids do their homework? Who gets the kids to the doctor? Who gives the kids their medicine? Who arranges play dates? Who knows everybody's favorite color? Who can spout off the teachers and principals at the kids' school? So it really depends, like how close of a call is it? Which factors a court will consider. If one parent is a drug addict and one is a church deacon, I mean, maybe there's not going to be as big of questions about who's giving bath time, but the closer the call is of which parent really is the primary parent, the more down into the nitty-gritty and weeds a judge is likely to get when considering the best interest of the child and appointing a primary parent. People often ask about joint custody of the children in their Texas divorce or custody case. And joint custody, in the way people mean, which usually means equal parenting time, that's what they're talking about, isn't really a thing. What they may be talking about is the legal part of custody with conservatorship in Texas, because there's a presumption that parents should be joint managing conservator when it comes to the legal decision-making abilities of their children. So that's when parents have the right to make decisions equally about their children's psychological, medical, and education-related decisions, versus they may be, what you could be referring to is joint custody in terms of physical custody. And maybe what you mean is if parents share 50-50 schedules, like week on, week off, or 2-2-3, some sort of a rotation where there's equality. But I think in asking about joint custody, people are getting at, is there equal footing between the parents? It's just that in Texas, it's not necessarily equal between decision-making and time spent with the children. You probably will see something a little bit different where even if you have the joint decisions, you have different parenting time. That's just how it works in Texas divorce and custody cases.